My name is Michael Kennedy, and I'm an attorney and senior partner at Estelle and Kennedy, a full-service law firm with offices in Upland, Los Angeles, and Mission Viejo, California. Today I will discuss labor laws governing meal breaks, rest breaks, and overtime in the workplace. This discussion is not intended to be legal advice for any particular case, but is intended as general information for public use. The Labor Code is a comprehensive statutory scheme that governs the obligations of employers and the rights of employees in the workplace, including employee personnel and payroll files, meal and rest breaks, and other requirements. The area of labor and employment law is quite complex, and the failure of employers to adhere to them can result in significant legal liabilities. Generally, California law provides that employees are entitled to a meal period of at least 30 minutes if the employee works more than 5 hours per day. However, if the employee only works for a total of 6 hours per day, the employer and employee may mutually agree that the meal period is waived. It is important to remember that both the employer and the employee must agree to this arrangement. If the employee works more than 10 hours per day, a second meal period of no less than 30 minutes is required. However, if the employee works no more than 12 hours per day, the second meal period may be waived by mutual consent of the employer and employee, but only if the first meal period was not waived. An employee must be relieved of all duty during his or her 30-minute meal period. If the employer causes or requires the employee to do any work, the meal period shall be considered an on-duty meal period and counted as hours worked, which must be paid. If they are not, the employer risks violating the law for failing to provide a meal period. In addition, if the employer requires the employee to remain at the work site or facility during his or her meal period, the meal period must be paid. This rule applies even if the employee is relieved of all work duties during the meal period. The issue is whether the meal period is truly duty-free, which contemplates that the employee can move about and do as he or she wishes during the meal break. This is not possible if the employee is required to remain on the employer's work premises. There are some circumstances in which an on-duty meal period is permitted. However, this is only when the nature of the work prevents an employee from being relieved of all duty and when the employer and employee have a written agreement for an on-the-job paid meal period. If there is such an agreement, the terms must state that the employee may, in writing, revoke the agreement at any time. Concerning rest periods, not meal breaks, California state law requires that employers must authorize and allow non-exempt employees to take a rest period that must, if practical, be taken in the middle of each work period. The rest period is based on the total hours worked daily and must generally be at the minimum rate of 10 consecutive minutes for each 4 hours worked. The DLSE has explained that a rest period is not required if the employee works less than 3.5 hours per day. The rest period is counted as time worked, and thus the employer must pay these rest periods. Also, reasonable bathroom breaks are not considered rest periods, and an employer cannot unnecessarily limit a worker's right to use the restroom facilities. Conversely, smokers do not have added rights to smoke breaks and are not entitled to take such breaks outside of the designated rest breaks to which they are already entitled. Further, workers requiring time to breastfeed and/or express breast milk must be given adequate time to do so and provided with an appropriate facility. A closet or bathroom, for instance, would not typically be an appropriate place for breastfeeding and expressing breast milk. In addition, most jobs have applicable Industrial Welfare Commission, which is known as IWC, industry and/or occupation orders that apply to an employer or a business. An industry order regulates wages, hours, and working conditions in specific industries. Wage, hour, and working condition regulations contained in an occupational order only apply when a business is not covered by an industry order. Overtime pay and conditions are also critical areas of concern in the labor and employment arena. Generally, a non-salaried worker is entitled to overtime pay if he or she works more than 8 hours in any workday or more than 40 hours in any work week. If the non-salaried worker works more than either of these times, he or she is generally entitled to be compensated 1.5 times his or her regular rate of pay for all hours worked over 8 hours in any workday and over 40 hours in the work week. The DLSE has explained that 8 hours of labor constitutes a day's work, and employment beyond 8 hours in any workday or more than 6 days in any work week is permissible, provided the employee is compensated for the overtime at not less than 1.5 times the employee's regular rate of pay for all hours worked in excess of 8 hours up to and including 12 hours in any workday, and for the first 8 hours worked on the 7th consecutive day of work in any work week, and double the employee's regular rate of pay for all hours worked in excess of 12 hours in any workday, and for all hours worked in excess of 8 on the 7th consecutive day of work in any work week. Also, not only may an employer dictate the employee's work schedule and hours, but typically an employer can require that an employee work scheduled overtime and take disciplinary action against an employee who refuses to do so. In addition, overtime wages must typically be paid no later than the payday for the next regular payroll period after which the overtime wages were earned. Overtime laws only apply to workers who are properly and lawfully deemed to be non-salaried employees. The determination of whether an employee should be an hourly worker as opposed to a salaried worker is complex. A worker's title does not determine the designation, and it is important for both employers and employees to understand that the nature of the work is what governs. Although the determination of whether a worker should be compensated on an hourly or salary basis depends on the particular circumstances and duties of the particular job, some general guidelines apply. For example, the employee must be paid a salary that is at least twice the state minimum wage for full-time employment. Also, the employee's primary duties must consist of administrative, executive, or professional tasks. In addition, the employee's job duties must involve the use and discretion and independent judgment. Again, there are many factors that ultimately will determine whether a worker is properly deemed an hourly worker or a salaried worker. These are just a few considerations that both businesses and workers need to consider when assessing their respective obligations and legal rights in the workplace. The penalties for violating meal, rest, and lactation periods are stiff and can quickly add up. An employee has the right to either file a wage claim with the Division of Labor Standards Enforcement Labor Commissioner's Office, or the employee can file a lawsuit in court against the employer to recover the lost wages. An employer who loses a wage, meal, or rest period claim may also have to pay the current or former employee's legal fees. Estelle and Kennedy is here to assist both businesses and individuals navigate this particular area of law. Thank you.